This is Fighting for What's Right. I'm Pam Jones with personal injury attorney Barry Doyle. Barry, can you walk us through the trial process?
So after jury selection is done, the next thing is opening statements. And an opening statement is really a summary of what you expect the evidence is going to show. It's not supposed to be argumentative like in the closing arguments where you're really trying to overtly persuade people. But the opening statement needs to be structured in a way that the story that they're going to hear will make sense. And it's really important that the story makes sense in that opening statement because witnesses are heard in a way that is not necessarily a cohesive story. You try to structure the witnesses, the order that they come on in a way that's really going to make sense, but there are other times where you can't do that because you have to accommodate people's calendars. There are some witnesses who are good for the beginning and the end of the story, but not the middle of the story. So how the actual evidence is presented doesn't always necessarily make sense in the sense of telling the story. But you want to be able to tell that story in the opening statement so that jurors really have a frame of reference for understanding everything that's to come. Now, once the opening statement is done, you have actual witness testimony. And as the plaintiff, as the party that's bringing the lawsuit, I have the burden of proof, so I get to put my witnesses on first. When I am presenting my witnesses, I question them first, and then the defense has an opportunity to do something that's called cross-examination. And if they cross-examine my witnesses, I have a chance to do redirect. And in theory, the scope gets narrowed each time someone takes a round at asking questions of a witness. And basically what happens is that I put on all the witnesses I feel like I need to carry my burden of proof and to establish all the things that I need to establish legally to actually have a valid, supportable case. Once I'm done with putting on my evidence, the defense will usually ask for what's called a directed verdict, which is essentially they're asking the judge to say that I don't have a case at all. And unless I've blown something badly, that's something I shouldn't have to worry about, but it's something that's necessary for the defense to actually file an appeal later. If the motion for a directed verdict is denied, then the defense puts on their case where they're going to put on as many witnesses as they feel is appropriate. They ask the questions first, and then I have the opportunity to cross-examine them. Once the defense case is done, in theory, I have an opportunity to put on what's called a rebuttal case, which is to address items that were brought up in the defense case that weren't really part of my original case to begin with. Once the defense case is done, they will again bring a motion for a directed verdict, which is usually denied. And then we will sit down with the judge and have what's called a jury instruction conference, which generally is done either in chambers or in front of the judge's bench, but certainly the jury isn't around for that. And that's going to be a conference where the judge is going to make a decision about which instructions are actually going to be submitted to the jury that will guide the jury's deliberations. The next step on this is closing arguments, and this is where you're really going to want to work hard to persuade the jury to find the way that you want them to based on the facts that have been presented and the law, and that's what the jury instructions are, is the law, and then essentially frame your closing argument around the instructions that the jury gets. So if the instructions say, I need to prove A, B, and C, I might put that instruction up in front of the jury and say, I have to prove A, and this is the evidence that you've heard on A, and this is why I've proved this. And work our way through the entire set of instructions. So the closing argument should be something that's going to help your jurors persuade other jurors to find in your favor. Once the jury actually reaches a verdict, there's a verdict form that has blanks that have to be filled in as to which side they're finding in favor of, and then assuming it's in my favor, the amount of damages. And literally what happens is the jury has a buzzer in the jury room where the buzzer goes off, and you're brought back to the courthouse to get the verdict, and then the jury gets polled, and they get asked, each of the individual jurors get asked, is this the verdict that you reached? And they always say yes. And that's the end of the case. At that point, you have a judgment that, in theory, you can collect, but most often the insurance company is eventually going to pay.
Barry, I've got one more question for you, and this is the question everybody wants to know. What advice do you have for people who want to get out of jury duty?
Pam, I'm embarrassed that you asked. I wish you hadn't, because I don't think that people should try to get out of jury duty. It really is so important, and people who are trying to get out of jury duty are really transparent. And I will tell you that it irritates judges no end at all. If you are really truly legitimately excused from jury duty, somebody's exercised a peremptory challenge on you and removed you from the panel, most often the judge will send you back to the jury room so you can go home that day. If the judge feels like you are not being entirely forthcoming about how you're answering the questions because you want to get out of jury duty, he may take you off the jury, but he may not excuse you to go back to the jury room, and he may leave you sitting in the courtroom for an entire day as an exercise in civics lessons.
Thanks, Barry. This is Fighting for What's Right with personal injury attorney Barry Doyle. For more information, visit our website at www.fightingforwhat'sright.com.